Ladies and gentlemen, the American jury and Bulldog Nation, I am going to do, it's going to be rather lengthy, but all of you that have been charged with a crime, you might be charged with a crime, you're currently charged with a crime, you got a loved one who's charged with a crime, I think you're going to really enjoy this because I'm going to describe from A to Z the entire criminal procedure process. The reason why I'm choosing this one today is because everything going on with Donald Trump. So I thought it would help you kind of understand that as well. First off, everything begins usually with an arrest. And I put real time up here because a lot of crimes, when I say real time, it is something that is hot, it's happening. Burglary, bank robbery, whatever it is, domestic violence, DUI. And there is a law enforcement officer who is there who makes an immediate arrest and then decides on his own what are going to be the initial charges as part of that arrest. Now, a lot of times there's not an immediate arrest. Law enforcement, and this could be FBI, it could be local police. Now, remember this. We have a dual justice system, state and federal. You have, in any state, city officers, county officers, state officers. In the federal government, you got alcohol, ATF, you got FBI, you got Homeland Security, so forth. And you got sheriff's departments. Some places you have both police and sheriff's department. We have that, for example, in Kenton County. But they're the ones that do the investigation of a crime that might lead to an arrest. So the arrest is not hot. Then you have on a lot of these places, a preliminary hearing. And a preliminary hearing, just so you know, after somebody's been initially arrested and it's a felony, that preliminary hearing is held to determine whether or not there's probable cause to send it to the grand jury for their consideration. A preliminary hearing oftentimes can be waived. Defendants waive the preliminary hearing because they know it's going anyway. Sometimes you hold the preliminary hearing. It usually only involves the police officer because you want to find out all the facts. Then sometimes you want to hold the preliminary hearing. If your case is so strong, you want to end that prosecution right then and there. I had 2 or 3 cases in my legal career where I held a preliminary hearing and the judge did not determine probable cause under the law and facts to send it to the grand jury. Case over. Sometimes lawyers don't want the case to end right away. We'll get to that later. All right, the criminal complaint. You can be charged all kinds of ways. And one of those is a criminal complaint. In other words, it has nothing to do with the grand jury. It has nothing to do with a hot arrest. You fill out the criminal complaint and it gets served on you. You don't get arrested. Then you have traffic cases. Speeding. That's a criminal. Well, actually, they're considered violations. Then you have misdemeanors. Misdemeanor is generally a charge where you're not going to have to serve more than a year in jail. And then you got felonies. Felonies obviously are the more serious. But you got traffic offenses, which are called violations, misdemeanors, and felonies. Now, you have some regulatory things, too, that are quasi-criminal as well. Now, a grand jury. Who's a grand jury? A grand jury is a group of citizens that county or a United States attorney convenes for them to present evidence over an investigation, usually done through law enforcement and police officers, but it can be other witnesses. A grand jury can convene and hear evidence in one day and decide to indict and not indict. In these Trump cases and cases like that, you have grand juries that stay open forever and ever and ever. And by the way, generally, a grand jury is that grand jury for that county for all the crimes that are coming before it. You don't have a separate grand jury. Sometimes you do have a separate grand jury. That grand jury generally only hears one side, the police officer side, law enforcement side, doesn't hear from the defendants. Now, A defendant can ask to testify to grand jury. Prosecutor can say yay or nay, go with their lawyer. But I want you to know something. This is really important. Just like that preliminary hearing, I saved a couple people from ever being indicted by asking the prosecutor to allow my client to testify at the grand jury. Again, lawyers don't like cases that go away. They don't make as much money. I always looked out for my clients. If I thought I had a strong case, if the grand jury heard from my client, he wouldn't get indicted. You do that because you cut it off. Grand jurors are supposed to be secret. Their indictment, the whole process is supposed to be secret. More and more these days, you have leaks coming out of grand juries. I mean, it doesn't seem near as confidential. But there are some people, let me give you an example. Me. All right, if I felt like I was innocent and the grand jury was convening, and nobody in the public knew about it yet, I would rather go testify to the grand jury and avoid the indictment in the first place. More people should do that, and they don't. So the indictment is what comes out of the grand jury. A grand jury doesn't have to indict. It's called a no bill. A prosecutor can also file criminal charges based on call and information. They just bypass the grand jury process. Now, once you are arrested based upon a hot crime or a criminal complaint or a grand jury indictment, you're booked. And what they do in book is, you know the process. They take your photograph, they print you, they process you, and they set bail or bond. So sometimes, as you noticed in these Trump cases, they're quick. You go in, you go out. Let me see. When I got arrested for not appearing in court that one day, I was in jail, county jail, for 2 hours in the evening before they set a $500 bond, and my wife posted it. So it just, that's usually the process. Now, by the way, judges set the bond. Judges set the bond, and there's usually a judge assigned to do that in every county. They rotate. Now, also, in Ohio and Kentucky, and this applies all other states. In Kentucky, we call it district court, handles misdemeanors and traffic. The felonies are handled in circuit court. In Ohio, misdemeanors are handled in municipal court and traffic, and common pleas is where the felonies are handled. Very interesting. In Kentucky, we have county attorneys who handle the district court stuff, and we have Commonwealth attorneys who handle the felony stuff. However, felonies with their preliminary hearings are actually held in district court first. In Ohio, you'd have one county attorney that handles it all A to Z. There's not two different types of prosecutors. Counsel. You have the right to counsel. It's one of your Miranda rights. By the way, remember Miranda. I should have put this in, but I'll stop here. Miranda is those warnings. You have the right to remain silent. You have a right to counsel. All those rights are only have to be told to you when you are in a custodial interrogation. You're in custody. Traffic stops, they don't have to give it to you. People get arrested for DUI all the time. Hey, they didn't read me my rights. They don't have to read your rights. The only time they got to read your rights when you're in custody and they start interrogating you. Now, please, your right to counsel. You do have a right to counsel. There was a famous Supreme Court case that said any indigent people have a right to counsel. There are public defender programs in both state and federal courts. My cousin Jim Moss was a federal public defender forever. You get assigned cases. You have to qualify for that based upon you don't have a job, you don't have any money, so forth and so on. I will tell you this. Unlike the vicious rumor, public defenders do a lot of criminal work. They know their stuff. They know the prosecutor. If you are guilty, public defender is going to get you as good a deal as anybody. If you're not guilty and you have to go through a big trial, that's when a public defender may not be all that great because they're used to wham, bam, thank you, ma'am, and not going to trial. That's just the way it works. You do not have to have legal counsel. You can represent yourself. The court will give you a big, long laundry list of everything they got to tell you before you can do it. But you can represent yourself. Guess who represents himself in everything? Me. And by the way, when they say a lawyer who has represents himself, or anybody who represents himself as a fool for a client, is bullshit. I crack up at all these lawyers, for example, in the Trump debacle, getting raped by lawyers. Why does Rudy Giuliani need a freaking lawyer? He represents himself. And I don't understand it. Arraignment. Arraignment is when you stand in front of a judge, your first call, and you get to say guilty or not guilty, which is usually the case. Now, people don't understand this. Even if you're guilty, your general advice is always to plead not guilty because it gives you time to sort out and figure out what the plea deal is going to be. You can also, in a lot of states, plead no contest, what's called an Alfred plea. Let me tell you what that means. That's a North Carolina case named Alfred, what it got named after. A no contest means you're not pleading guilty, you're not pleading not guilty, but you recognize there's enough evidence to convict you. That's what no contest means. Those are your options in arraignment. Now, after arraignment, there are a lot of status conferences. And the reason why these cases take so long, these big criminal cases, is there's always issues that are getting sorted out. And the courts will keep it on their docket. Every month we're going to be back, see where we are. So status conferences are big. From the time you plead guilty or not guilty to arraignment, there's something called the discovery process. The prosecutor has to give you all their evidence that they got against you, including exculpatory evidence. That means evidence that is on your side. A lot of famous cases where they didn't give evidence, which is sick, but that means the prosecutor wants to convict somebody, even the wrong person. So exculpatory evidence has to be turned over too. Photographs, you name it, any evidence they got, witnesses list, all that stuff. This is the discovery process. And that goes on for a long time, thus a lot of status conferences. Now, you've heard me say motions, and all these highfalutin lawyers always say motions, instead of telling you that a motion merely means a request. That's what a motion is. It's a request. There are countless motions that can be filed in a criminal case. Motion to dismiss because you can't prove your case. Change of venue. You're basically saying, hey, I can't get a fair trial here. They are rarely granted. Why? If I commit a crime in Kenton County, the people in Kenton County have a right to decide my fate, not somebody else in another county. The only case that I remember being moved around here was the Delta pilot murder case where Judge Summey removed it to Fayette County and it was tried in Fayette County. That was a long time ago. Bond hearings. You're going to have a lot of hearings and motions on bond. You can have a hearing to reduce bond. You can have a hearing for no bond. By the way, being let out on your own reconnaissance is an option. But there's lots of motions dealing with bond. How do you post bond? Sometimes you got to do all cash. Sometimes they allow you property. Sometimes they do you 10% cash. You can go get a bondsman and a bail. There's it's a complex thing. Lawyer will help you through it. Excluding evidence. This is one of the biggest issues. If you win on the exclusion of certain evidence, that could be the whole case based upon the exclusion of that evidence. Why would evidence be excluded? It was obtained without a proper search warrant. It was obtained without a proper subpoena. It was obtained. Now, there's this famous case that uses the phrase fruit of the poisonous tree. So it's like if the evidence is poisoned, everything that comes from that would have to be excluded because the fruit from the poisonous tree, Josh, is not allowed to be introduced into evidence. There's countless motions to exclude. A lot of times there's motion to compel evidence. You can't make this up. When I represented David Dooley out in Boone County, The prosecutor kept getting DNA, and the DNA kept coming back, not David Dooley. And I love Judge Schran, but Judge Schran kept letting them request it. And they delayed that trial all the way until I retired. And I didn't get to try the case, which I think why he got convicted. But the bottom line is they kept requesting delay for DNA. By the way, there was never any DNA evidence. Speedy trial. You hear this all the time. The right to a speedy trial is the defendants, not the prosecutions. Speedy trial. Now, I should have put this in here, but now's a good time to stop. The Constitution and the Bill of Rights is where we get all of these rights from for being a criminal defendant. Then you have what's called case law. States have case law. Each state has their own Supreme Court. And then you've got the United States Supreme Court. Case law is judges interpreting so many issues. So the law and the criminal process comes from statutes, the Constitution, and courts. Now, the Constitution, lots of it. The Sixth Amendment is big. The Sixth Amendment is the one that gives you a right to a speedy trial. The Sixth Amendment gives you the right to a confront and cross-examination of your accusers. By the way, there is nothing in our criminal justice system more important than the right to confront your accusers and cross-examine them. You do. It is huge. And then, of course, we have both Fifth Amendment and 14th Amendment giving us due process, substantive and procedural due process. It's all wrapped up in the Constitution, the Bill of Rights, case law, and everything else. Pretrial conferences. This is when you're getting a little closer to trial. So you're sorting out the issues. You can have a whole lot of them. The number of status conferences and pretrial conferences that are going to happen in the Trump prosecutions are many. And I was the first one to say it, and you watch. None of these are going to go to trial before the election next year. Plea deals. The justice system would not work if there were not plea deals. 90 some odd % of cases are pled. That plea, you get, countless different options. You plead to this, they drop this charge, so forth and so on. It's a negotiating process, usually done at pretrial conferences with the prosecutor and your attorney. Now, this is really important to know. In the federal system, you're going to love this. In the federal system, 97% of the time is the statistic that if you're charged with a federal crime, you either plead guilty or you're found guilty. And you know why? This is common knowledge. The feds generally, by the way, this doesn't apply to these Trump charges. The feds generally don't charge you unless they got you dead to rights on a wire. Seriously, they love wiretaps. They have the power to wiretaps, and they love freaking wiretaps. If you're a criminal, don't say a lot of stuff on your phone. Because if you're a criminal, they probably know you're a criminal, and they're listening to you. And let's face it, if you are captured on a wire saying you committed a crime, or you're dead. You can't explain that away to a jury. There's no nuances like a document, what a word means. And you get to argue, well, this is what I mean. That's why the feds really nail you. By the way, this is kind of funny. In the Fed world, although they get you more, if you ever want to commit a crime and you have to commit a crime, commit a federal crime. And Josh, here's why. The federal prisons are a lot nicer than state prisons. You don't want to go to a state prison. Have you seen that show, Blackbird, that series Blackbird? You ought to watch it. It's a true story about a serial killer in Illinois. And this drug dealer, his name was Jimmy Keene, went into the Springfield, Illinois prison, state prison, to try to get a confession out of the serial killer. And the prison was so bad, he didn't really want to go. You don't want to go to state prisons. So commit federal crimes, not state crimes. All right, the trial. Everybody knows that a trial in a criminal case, you have to be found guilty beyond all reasonable doubt. You ready for this? You don't get to define that. But think about it. Beyond all reasonable doubt, which means if you got reasonable doubt, not guilty. By the way, but while we get on reasonable doubt, there's something that's also you're presumed innocent. I should have put that up there too, presumed innocent. Folks, every time I've tried a case and I've talked to the jury about presumed innocent, then I say, would you like my client to testify? They don't raise their hand. Presumption of innocence, BS. You are guilty until you prove yourself not guilty. That's the way it is. Presumed that. Now, you have a lot of these people don't call their defendant because they don't think the prosecution proved their case technically. And that can be true a lot of times. If you've noticed, more and more trials, the defendants are testifying. I can tell you right now, here is my maxim. If you're innocent, shout it from the mountaintops and testify. That's going to be your one chance to convince that jury. And if you don't, then you're found guilty. Don't whine about it. Who was the bathtub killer up in Ohio? He got 3 trials, was found guilty every time. Okay? He never did testify. And then he moans and groans that he's innocent. Then why not testify? It's insane. And by the way, you don't have to be perfect. I got Sarah Brady found not guilty, accused of having a sexual relation with a student because she testified so well. Was it perfect? No. But the jury sits there and listens. If you're on the jury and somebody testifies, don't you think more up now? Don't get me wrong. There's a lot of guilty people, Josh, that take the stand and their testimony is absurd. But I'm just saying, if you're innocent, you ought to testify. Order of presentation. The prosecution goes first. Opening statement. They call their witnesses first. You get the cross-examination. Then you can move for a directed verdict. You can say, hey, prosecution didn't prove their case. Ask for the court to dismiss it. It's not approved. Then the defense puts on their case. Then prosecution goes first and last, rebuttal, because they have the burden of proof. By the way, in a civil case, it's switched. Bench trial or jury trial. More defendants ought to ask for a bench trial, and they don't. Bench trial is easier, costs you less money. And if you got a judge who's open-minded and not a Nazi, you might have good luck. They understand reasonable doubt. They're more likely to say you didn't prove. You know what? A judge is more likely to say the prosecution didn't prove their case, even though I think he's guilty, than a jury. You think a jury thinks he's guilty, but they didn't prove their case? Yeah, but he's guilty. They're going to find you guilty. More criminal defendants ought to try their cases to a judge, in my humble opinion. You pick a jury, you get to do what's called voir dire. You get to explore all their options. You get to kick a certain amount of them off automatically. You get to kick jurors off for cause. You get your jury, they get alternates. And then you got all these issues around juries. You know, should the jury be sequestered? That means they don't get to go home. They get to go stay in a hotel. You've seen that on the news. Juries aren't supposed to talk to each other about it till it's over. Trust me, they do. Juries aren't supposed to talk about it to their spouses and friends. Trust me, they do. Jurors aren't supposed to research and Google. They do. It's an imperfect process. Also, on a criminal case, the jury verdict has to be unanimous. Unanimous. 100%. A hung jury is when they can't decide. And by the way, a hung jury is a win for the defendant. And when you get a hung jury, the prosecution has the following options: retry you or drop it, or you take a plea to a lesser charge. Evidence and documents, it's everything. Photographs, documents, emails, text messages, everything in the world. Here is the rule of evidence. Anything that is relevant is admissible. Anything that is not relevant is inadmissible. And the battles and the fights and the court cases deciding that are voluminous. And it's a big battle. The evidentiary rules are simple, but how that's interpreted is crazy. Witnesses. You can call any witness you want who has material information. When in doubt, leave them out. I've seen a great case blown up because somebody wants to call one witness. It happened to me once. You're going to love this. I was winning. It was a civil trial. I was winning this case. And the mom wanted me to call the son. And I didn't want to call the son. And they were like militant about it. All right. By the way, the son was a bad guy, burglar. I said, I don't want to call him. I don't want to call him. By the way, I think it's the only time I ever gave in. All right, I'll call him. Within 5 minutes, he blew the whole case. I mean, it's unbelievable. So you got to be careful who you need to call. By the way, you don't get to prove your case more than once. Let me give you an example. If one witness proves your case, why call two witnesses? Proving it 5 times doesn't make it any better. You only got to prove your case once. How do you get witnesses there? Hopefully voluntarily, but you can subpoena people to the trial. Verdict. Once the verdict is issued and it's read, the judge will put on a judgment entry and off to the court of it. But there's a lot of post-trial motions. The jury didn't properly weigh the evidence. There's jury misconduct. I mean, there's countless post-trial jury motions. Then if you're convicted, you've got sentencing. And sentencing options are all over. There's fines. There is restitution. There's jail time. There's probation. There's parole. I mean, all kinds. We're going to get to that more. Double jeopardy. You hear that all the time. Here's what double jeopardy is. You cannot be tried for the same crime more than once. You cannot be more than once. So Josh Wentz, this is the extreme example that I love to use. If I'm charged with murder, let's say I murdered Sabrina Cain because I got tired of her not producing my show the way I want to do it. So I killed Sabrina Cain. And we go to trial and the jury finds me not guilty. Do you know I can walk out of that courtroom, stand in front of that jury, the whole public and those cameras and say, I did it. And they can't charge me. Isn't that something? Now, a lot of people, when they've done that, if they've testified, they charge them with some BS perjury charge. But you believe that? If you're found not guilty and you're guilty, you can confess the same day and they can't charge you again. I advise you not to do that in abundance of caution. All right, appeals. Once you're found guilty, by the way, if you're found not guilty, the prosecutors don't get to appeal. That's kind of nice, isn't it? But if you're found guilty, you can file an appeal. If you win your appeal, you can get a new trial, which means you do it all over again. 2, you get an outright win. The Court of Appeal says you should have never been charged in the first place, and you win. Or you lose. Now, pending appeal, what you want, this happens, this is what you want to have happen. By the way, Devin Archer just won from the Supreme Court the right to stay out pending appeal. If your sentence is, let's say, 1 year, man, that judge has got to let you stay out pending your appeal. Why? Appeals take years. You will have served your time. So if you win your appeal, it's meaningless because you've already served your year. Now, if you got to serve like 10 years, 20 years, sometimes they don't let you do it. If I was a judge, unless this guy was I thought he was stone cold guilty, he was never going to win his appeal, I'd let them all out pending appeal. I just don't think it's fair. But that's a big deal. You see it all the time in these shows and news. Taken immediately into custody. That jury convicts, off to jail you go. So that's a big issue on appeal, whether you're free pending appeal. Punishments, I covered this a little bit. Fine, jail, all over the place. Now, here's some words. Conditionally discharged. Let me give you an example. In my big menacing charge, I was sentenced to 90 days conditionally discharged. What does that mean? I'm a good boy. I don't have to serve the 90 days. If I'm not a good boy, the judge may or may not let me serve 90 days, or he may not. People break probation sometimes, and they get second chances. But the bottom line is, that's a big issue. Also, consecutive and concurrent. If you got 2 charges and you're sentenced to 5 years on both. If you're the defendant, you want that 5 years to be served consecutively. Concurrently, same time. Not consecutively back to back. Because if it's back to back, you got to serve 10 years. Now, the judge is in charge of sentencing. Juries can recommend sentencing, but the judge is the one who renders it. The judge can ignore the jury all day long. Now, let me tell you some more things about this process. In state courts, judges have a lot more leeway to grant you probation, do all kinds of fancy things with your sentencing. Back, I guess it was in the 80s or 90s, they came up with this terrible thing in federal guidelines called federal guidelines, minimum sentencing, blah, blah, blah. They wanted it to be consistent. So if you got lucky and got easy judge, and poor Josh Wentz got the hanging judge, same crime, I get 1 year, Josh gets 10. That's not fair. However, what that did is took away the humanity that a judge can lay down. Judges are smart. They've been doing this. They go through, they know who the slime balls are. They know who the good guy is that did something wrong. In my opinion, federal minimum sentencing guidelines is bullshit. It shouldn't be. And I think there's been some amendments of that in recent times. But the judge makes the sentencings. Now, on real bad cases, like somebody is cold-blooded murder, it's a terrible crime, judges politically rarely will mess with what the jury did. They generally don't do that because of that. Probation, in a state courts, depending on in Kentucky, you do have a chance to get paroled. In Ohio, I don't think they have parole actually, but parole is when after you serve a certain part of your sentence, you're good to go and you can get granted parole. We just had a famous parole. The one of the killers in the Charlie Manson just got out on parole after decades and decades and decades. Kentucky has parole. I don't think Ohio has parole. On these sentences, you also have to serve a certain amount. In Kentucky, it used to be, if you got 5 years, you really only got to serve 20%. You get out in 1 year. I don't know if they've changed that. I don't think they have. Certain crimes, you only got to serve a certain amount. Ohio is much more harsh. Okay, pardons. An expungement. The only person that can give you a pardon if you're convicted of a state crime is the governor. And generally, oh, by the way, they can give a commuted sentence too, where they just say, okay, you served enough time, we're letting you out. So that's not a pardon. It's called commutation of your sentence. You served 5 years, you got 5 more, they commute your sentence, you're out. And a pardon can only come from the governor. Now, generally, they don't do these till they leave office. Matt Bevin famously pardoned in his anger and bitterness a whole bunch of folks that he should not have pardoned. And that probably ended his political career if he wanted to make a comeback run for governor this last go around. But I'm just saying, it's generally not done. President have that pardon power, generally do it at the end. There's less blowback. But a president can pardon somebody anytime. Now, misdemeanors can be expunged. In most states. Kentucky allows you to expunge. Expungement means it's like it never even happened. How do you like that? Misdemeanors can be expunged after a certain period of time. Felonies do not get expunged. You have to get a pardon for that. Now, there's some other sentencing things that they've popped in my mind. One is called diversion. On minor offenses, like in the state of Kentucky and a lot of states, you can get diversion, which means you're not guilty. You just got terms of diversion and you do X, Y, and Z. And once your diversion period over, it's great. The famous Sarah York case, Sarah Jones York case, she got 5 years felony diversion. And after 5 years, it's off her record. Sarah has a clean record because she followed the terms of diversion. By the way, these terms of diversion and probation are very difficult. They always include no alcohol. If you're a heavy drinker, be careful. 2, no guns. Can't have a gun. By the way, none of it makes sense. It's like, based on what I was charged with, what does not having a beer have to do with that? Or why can't I have a hunting rifle? I mean, it's really unfair. And they load you up. And then when you get in the system, you're screwed. Probation and parole officers are Nazis. If you get a cool one, you're lucky. By the way, they're the ones that if you screw up, technically, got a funny story on Sarah York. I told her to go do an interview with Bill Cunningham. She went and did an interview with Bill Cunningham. Somebody contacted probation parole. I forgot she wasn't allowed to leave the state without permission. We laugh about it now. Of course, the probation and parole guy did not ask her to be revoked. By the way, it's up to the judge. So a probation and parole person could ask for revocation. You get to have a hearing with the judge who decides whether it's revoked. But these probation and parole folks can be tougher than nails. And guess what? You can't sue them. I mean, they have all this power. It's like the child custody issues. You know, these social workers, they have immunity and they can be tyrants. So I hope you get, if you got probation and parole, I hope you got a nice one. A lot of criminal defendants rather would serve their time than get stuck in diversion. Once you get in the system, it sucks. You're in the system. Another issue I just popped in my mind, gag orders. Gag orders are really rare. You've heard this. We're going to try this case in my courtroom and not outside the courtroom. Well, you got the First Amendment right to defend yourself. And when you're dealing with somebody like Donald Trump, where he's a politician running for office, he really has the right to defend himself. Let's face it, folks. If you're charged with a crime, you ought to be able to speak out about it, right? Gag orders. Gag orders are awful, in my opinion. So, folks, I have covered a lot of material here. Criminal procedure A to Z. And I told my producer, Josh Wentz, I think this will be very popular and watched by many, many folks. If you got a question, you can email me at eric@ericdeters.com, 859-250-2527. This isn't legal advice. This is a educational lecture. It's strictly educational. It's 100% free. If you're charged with a crime, text me or email me, tell me what's up, and I will hook you up with the right lawyer that I'm connected with. I got a whole army of lawyers, Ohio, Kentucky, federal, state. I'll put you in touch with the right person. Now, remember, I can give you legal advice as long as I don't charge you for it as a friend. So there's no money passing for. That's not the unauthorized practice of law. If it's something little that I can guide you through, I'll save you money. Because I can tell you what to do and not to do just as your buddy, and you won't have to pay a lawyer. Be on guard about lawyers. With lawyers, you need somebody who cares about you, is fair, and is not just going to scare the hell out of you to get paid more money. There's a lot of good criminal lawyers. There's a lot of fair criminal lawyers. But there's a lot of jackwagons out there that want to take advantage of you, scare the hell out of you, and you bill the hell out of you. Remember what I always say. Lawyers, plumbers, electricians. You need somebody who cares about you, and knows what they're doing. If they don't know what they're doing and or they don't care about you, you're in trouble. So that's what you want. You want a lawyer who gives a damn and knows what they are doing. This is the Bulldog. Every dog has their day. Stay out of trouble. No menacing.